because of my scheduling changes and looking at the syllabus, because of the teammate success over the weekend, I'm not going to be here then on the second Thursday in March. So what I've decided to do is that midterm examination, for those of you that are taking it, scheduled for March 1, I'm going to have then the following week, which will be March 8th instead. And you'll draft a complaint for injunctive relief where it presently says Section 7 in Section 8 on that Thursday. I'm going to give you a revised syllabus and just want to give you a heads up on a slight change with respect to the scheduling. So for those of you that are going to be taking the midterm exam, that'll be March 8th. And that's really only for the in-class students if you choose to take it. The online students, they submit the questions that are posted for each section, and that constitutes their midterm. So you guys still have time to decide to do it. I just wanted to tell you that there is a little bit of a scheduling change for those that are planning on taking the midterm. It'll actually be March 8th, just before you get the week off for spring break. Okay, I'll give you a revised syllabus, and I'll post a revised one online. It just changes those Section 7, Section 8, and Section 9 just slightly. Okay?
Okay, I have a question. For us, that's going to do the questions.
Yes.
So we will submit all the questions all together on that date, or?
You will submit, those of you, if you choose to submit the questions that are posted online instead of, in lieu of taking the midterm, for all of those of you that are in class and are required to take the midterm, you will submit them by, I think it's March 18th at midnight. That's correct. So before the week is over, you will submit them. If that, are you sure it's a Sunday? That's what I intended it to be. Sunday at midnight.
Sunday is the end of spring break.
That's what it's intended to be. Before school again starts on Monday. So the 18th by midnight. Okay? So that way it doesn't interfere with your next week's worth of work. Yes?
Would you like them to do 3 questions?
No, I don't intend to take your 103 questions. I hope you've done them. I hope you listened to the presentation again. I know some of you have done them before, so if you just went and copied your old ones out, that's bad for you. Those of you that chose not to do it, that's bad for you. At this point now, you've all got through first year. You're adults. If you think you know better than I know how you should be learning, that's your call. I've done this a little longer than you. But I'm not going to bother to pick them up and collect them and check them off to have you, force you to do them. You should, you all should do them, whether you've had me before or done them before or not. Civ Pro, and if you look at my old exams, you'll see the same thing. This Remedies is really sort of an accelerated or advanced Civ Pro. And that's why I'm going to use this case to illustrate a lot of the things that you already should know tonight. But really what you're looking at is just adding a lot more flesh to it here. So when you get a problem in Remedies, it's not just where you're going to go and why, but it is that at least, plus all of your remedies, all of your damages, all of your potential problems, all of your other more advanced issues like discovery and everything else you'd see, the evaluation of damages, your potential forms of relief, all of that is expected in a great deal of detail in your exam. So for those of us that aren't on the same page, because some of you guys had me, some had Martin, I think the 103 gets us closer to the same page. What it also does, because some of you had Civ Pro last semester, some of you had it two years ago. It gives you, it brings you back to where you need to be able to do well on the final exam. So that's the purpose of it, and I wouldn't necessarily skip a step to start to reacquaint yourself with it. The other thing you all should know is on the essay exams, the essay exam when you take the bar exam, you know, there's often a couple of questions at least where you can get some serious points for your knowledge of Civ Pro and jurisdiction and things like that on the exam. So it's important to keep it in the front of your mind. So I'm going to grade you on it at the end of this, but how you get there, I have an idea as to how you should get there, but I'm not going to collect them and check it off. I don't think you need that at this point. Some of you probably do, but if you don't think you do, I'm not going to force you to do it. So the online people, you guys know, no one has to turn it in. You should do it, and you should then keep it for your own review at the end of the semester. Okay? Yep?
What are the questions that we can choose to turn in for the midterm?
If you look online, there's a posted for each week. I am going to post them collectively as well, so people can see them. And well, actually, I'm going to post them probably the end of this week for the first up to the midterm, so people can look at them and start to get comfortable with where they are. There's usually about 4 or 5 questions for each week. It's not a whole bunch of questions, but much of it may well be what we've discussed in class. There may be occasionally where we haven't discussed it in class, but it's there. But it really talks a little more about asking you to think a little more about the cases. And some of it simply is just dragging out what's some essential law from those cases that you should start to get familiar with, like how do you find an agent responsible for, how do you find a principal responsible for the acts of their agent, things like that. Pretty basic law that's reasonably well tested on the bar exam. And so I'll post them all at the end of the week. You can take a look at them. But if you've done your reading and you've paid attention in class, they shouldn't be incredibly difficult questions. They're not incredibly difficult questions. Yeah?
So, am I correct in thinking that on any exam essay that we do for you or even for the bar that relates to remedies, the SPV analysis should take a backseat and just really focus on?
No, I don't know why you think that. Because that seems to be the exact opposite of what I just said, doesn't it? Wouldn't it? Didn't I just say that I see remedies as sort of advanced civ pro, all of the basics plus more, right? I mean, because if I give you a problem, I just don't want to hear about discovery with it, or I'm going to go get an injunction. I want to know where you're going to go get that injunction, why you're going to go get that injunction, what do you think the likelihood that the court is going to do when they assess the 5-part test. I want to know how you're going to argue against the injunction. I want to know what the procedure the court will use in evaluating whether the injunction should be granted or not, and the process for doing that and your rights in that process. It's all of the basics I expect to see, plus the advanced stuff. So that raised question is just to make sure we're all on the same page. I expect to see your analysis on subject matter jurisdiction, personal jurisdiction, and venue. Because if I give you a problem, I need to know you know where to go to file the suit. Okay? But that's like a given. Okay? That might get you D+. But without that, you might not get a C. So we're on the same page. So we got to do that, but then we're going to add a lot more to it, because we're going to see that the analysis and the process for how that injunctive relief is granted is a pretty detailed and disputed process at times as to how it works. But in the real world, we seek and oppose a lot of injunctive relief. And you guys need to know how to do that. You know, it's probably one of the few areas now where we still do a lot of it by oral argument. You know, when I was first a lawyer, back when the earth was flat, we got to argue every motion. I'd go in multiple times a week and argue motions, both pro and con, all sorts of motions. Motions to dismiss, motions for summary judgment, injunctions, you name it. The more modern trend has been a way to allowing the advocate to come in and have that motion session to argue in front of the judge and then get some feedback from the judge. The much more modern approach is a lot of it is done by paperwork. You submit your brief and your memo and your motion in support of it. They submit a brief and a memo in opposition. And then the judge will look at the papers and oftentimes decide on the papers whether he or she needs to hear you. So injunctive relief is one of those areas where it happens very, very quickly, so you have to be well prepared. And B, that you do have that opportunity to get before the judge and really advance your arguments both for and against. So it's important to understand how that process works and what rights you're entitled to in the process, and what your arguments the good arguments you could be making to either be successful or to deny someone else's relief. And again, I can't stress enough how quickly that happens if you think about it, right? I mean, you all know, you take the theory, right? You know a TRO can be granted without the other side being present. Pretty rare, though, okay? Okay, yeah, I heard I can get it without giving the other side notice. The reality is you go to court The judge, you know, you're asking for extraordinary relief, right? That's the language. Take your language from the cases. You're asking for extraordinary relief, and then you're asking that it be done without even telling him what it is you're asking the court to do. As a practical matter, the court is pretty reluctant to do that. However, when we think about notice and the whole long, cumbersome process, that may not take place either. They may simply say, I'll give you a short order of notice, you come back the end of the week and we'll argue it. So a short order of notice is a summons with a return date saying, here's a summons, serve it on the other side, you'll be back in 4 days. So he gets the notice, he just doesn't get the time period that the rule usually allows for. Or the court may say, if you really do have an extraordinary case, call him if you know who it is. Tell him you're here now, and that I'm going to hear you at 2 o'clock. And if he wants to be heard on this, he better be here. But you don't even always know whether the other side is represented in some of these cases. And so sometimes they might go with a different process. But either way, even if you have to give them a regular notice, this whole case, for a practical purpose, could be over in the first 30 days. If I get the injunction and I get to hold that for the next 2 years, he's got to be realistic about whether he can live with that injunction and what the cost is to him. If I don't get it, then maybe it means that I've got it does mean I've got a harder road to hoe here, because I said I was suffering immediate and irreparable injury, and now I'm going to have to suffer that for another 18 months perhaps. I may not be able to take that injury for that long and continue to litigate. So what I'm trying to convey to you is that you have to be well prepared and understand in detail what your arguments for and against that entire process are, and it's all going to be at virtually warp speed. And so that's why I think it's important to specifically understand what your rights and what you can insist on with respect to how that process operates. So, but listen, you know, let's go back to the basics. If you can acquire personal jurisdiction over me, we're not going to get to that argument about whether injunctive relief is appropriate. If you're in the wrong court seeking that injunctive relief, I don't have to worry about making my next level of arguments. And so that's why the basics are fundamentally important still, but it's not just the basics. We expect, okay, if all of that's done right, now I've got to look at the higher tier of arguments that you should be capable of making, and I want to see all that, right? I tell people I think this course is great as the very last course you'll take in law school, or it does make sense to follow Cit Pro as well. But this hopefully will put a lot more of the different pieces together, and you need to start to think about it like that, because client comes in, it doesn't say towards a contracts problem on their head, right? They have a problem and they need you to figure out from a variety of possibilities where do you think the best course of action is. Okay, and that's what I'm looking to see here. I'm not looking to see, you know, no offense, first year student work where you just focus on a narrow piece. I want to see the whole understanding of how all these courses and stuff fit together. Okay? But especially in Springboard is Cit Pro, obviously. Questions on that? No, we're good? Then let's take a look at, we're now on Section 3, and again, another one of my favorite cases. Business relationships, jurisdiction, trademarks, service marks, general, Chapter 93A, and franchise relationships. So we got to think a little bit about jurisdiction. We'll see that in Burger King versus Rudzowitz. Trademarks and service marks, obviously intellectual property. You don't necessarily tend to think, you know, you're going to have anything to do with it, or you may not have thought about it. I never did in law school, but I've probably had about a half a dozen different cases involving it in some fashion. So again, it might be something you want to think about, because there's litigation that surrounds it. There are issues about how you protect your intellectual property. We'll talk a little bit about that. But that might be something you want to start to think about. I think especially if I had to predict at least some of the additional areas that are likely to have more litigation in future years, it's that area because of the widespread abuse of people's trademarks and service marks and the like by way of the internet and the new media that's available. So that's something I think if I were you guys, I'd want to know a little more about. I remember when I was in Boston, we had two dental companies litigating over the use of some service marks and the like, and there were issues of service marks and the like. One of our graduates, a good guy, had a piece of litigation in federal court over a new street hockey puck that his client invented and someone stole, or not someone stole, one of the major manufacturers stole, and ultimately he made pretty good money off that case. So it is an area, this is an intellectual property area, that can be very, very lucrative as well. 93A, and we're going to see that more when we look at Anthony's Pier 4 and Zapata, which will be Thursday. 93A is a Massachusetts statute. It protects both consumers and businesses from unfair trade practices. Very, very important statute, both from the standpoint of a lawyer working in Massachusetts, as well as the bar exam. That's one of the state areas they like to test, and it's something you should be familiar with. It's a relatively short statute in all, but we're going to look at it a little bit and the remedies it provides. The biggest reason we start to think about it as a practitioner, it's not just, I mean, it's the reason it's forefront in our mind, is that if you're successful on a 93A claim, and again, it applies not just to consumers but to businesses, the business v. business transactions as well, is that you get treble damages plus attorney's fees if successful. Treble damages obviously means 3 times your actual damages. So if your claim is for $1,000, you've just made $3,000, plus all the attorney's fees it took in being successful. That's a game changer, right? If I've got a viable 93A claim and I plead it, then that means the other side should be assessing the potential risk here a lot more seriously, because not only is there always a risk of losing any case that you take to trial, but here the risk is not just losing, but then the court trebling that amount, plus providing the other side all their attorney's fees in order to be successful in succeeding on the 93A claim. That's a lot more potentially than the $3,000 they're going to get on trebling the grand. That could be tens, if not hundreds of thousands of dollars, depending on the case. So we plead this 93A, and we'll talk a little bit about that as well. But the first case is a franchise relationship case. And I think it's important for you to start to think about the franchise relationship, because I don't know what the statistics are, the actual statistics, but to the extent that we have people that want to get involved in businesses, an awful lot of individuals end up feeling that the appropriate route, because they see the support there and the existing established business model, is through a franchise relationship. So you may have people come to you and want you to review those agreements and the like. And those agreements are usually, you know, yay thick, and yay thick is probably about 1 inch thick. I don't know how much modification they're going to take when you decide to review it and see that it's horrible for them. But the fact is, if they've brought it to you to look at, then you better be able to interpret it and tell them what you think is wrong with it. And not just wrong with it because, again, this is, I think, at least in part, the balance between the lawyer as the counselor and the lawyer as the deal breaker. Right? A lot of people see us as deal breakers, so they say, I don't want you to break this deal. I want you to try and keep it. I want you to keep it together first and foremost, and tell me, you know, what we can do to fix it if we can, and what the problems are. But you know, the fact is, a lot of times when we look at an agreement, we see that it's pretty one-sided, and the franchise relationship is one of those ones fraught with difficulties. But there are both federal and state statutes that might provide some protection. And so I want you to think about, well, what if one of your friends or some client brings you the franchise relationship and it's Kentucky Fried Chicken or it's Dunkin' Donuts or God knows what. They think they've got a pretty successful business model, and we're using one of those as opposed to one of the ones that maybe even more, give us a couple $100,000 and let's hope this good idea works. And that's obviously something you'd have to be more careful about as the counselor. And I don't know to what extent he provides business advice as opposed to just legal advice. I mean, it seems like a McDonald's is a cash cow, maybe Dunkin's too, but my guess is there's an awful lot of other ones that are much further down the line that might be less revenue friendly, but just as expensive, and what's your role there is what I'd like to think about. But I want to talk a little bit about, obviously, Burger King versus Rudgewitz and Rule 4. Let me go to Rule 4 first, so we get the rule out of the way at the beginning of the week, and then we'll go back to Burger King versus Rudgewitz. You guys understand the basics of due process. Notice and the opportunity to be heard is what we look at from a civil standpoint. When we start to define due process, what it really means is notice and the opportunity to be heard. Well, Rule 4 of the Rules of Civil Procedure is how we provide that notice and hopefully, ultimately, the opportunity to be heard. So when we file a complaint in court, it gets a docket number, and you give them an extra buck or two, maybe 5. How much is it more than that these days, Melanie?
I don't know because we don't practice them.
Well, what is it in New Hampshire? Do you know? Anyone know what it is in New Hampshire? Cost of a summons?
$5.
That's $5 here now, and 5 in New Hampshire.
No, Matt.
5 in Mass. 5 for a summons,
Yeah.
and we don't know what it is in New Hampshire. Maybe it's free, right? Live free or die, Melanie. Could very well be. But at any rate, you enter your complaint. Depending on how many defendants you have, you're going to give them money for summonses, and then you're going to need to serve those summonses, because the court doesn't send out that notice. It's your obligation to ensure that the other side gets that notice, and we do so by way of providing them with a summons. You put the docket number on it, the name of the case, it tells them they have 20 days to answer, exclusive of the day of service. And now what? Because now you've got to get that process into the hands of someone capable of serving it. And there's also a manner in which it needs to be served. You know, we tend to think, when we come into law school, we tend to think, well, everyone gets in-hand service. And that's just not the way it works at all. The fact is, very few types of cases have to be served in hand. But if you were trying to figure out how to serve someone, in addition to talking to our friendly process servers, and process servers can be constables, they can be sheriffs, they can be marshals, so there's a variety of different process servers. You know, the rule actually even provides for disinterested people being the server, but that seems to me, to be a little, we've done it on rare occasions. I don't think it's worth it. Sometimes actually we've brought up an appointment for a special process server simply because we want to get it done quickly. We're going to use someone who is a process server that just may not be one in that region, because that's the other part of it. You're not necessarily authorized to serve process everywhere in Massachusetts. For instance, as you might guess, the Essex County sheriffs can serve process in Essex County, where we sit here, but they wouldn't be able to serve it in Boston. There are constables that are appointed for various cities and towns, but they can't necessarily serve outside the city or town. So that becomes an issue, but it's actually a relatively easy issue, because at some point, relatively soon, either use your red lawyer's diary or otherwise, you are able to figure out who can serve where and make sure that they get the process. If you look at the Rule 4, it tells you what that summons has to say. So you've got to complete it properly to make sure that you then provide it to whoever it is that's going to serve them. And part of it, obviously, is, I mean, again, this is pretty routine, but, you know, my guess is the first time you do it, it might seem a lot less routine. Obviously, it is a lot less routine, but it might seem a lot more complex than it actually is. But at any rate, at some point, you've got to figure out how to serve it. And as a general matter, you're going to get that into the hands of someone who is authorized to serve it in all likelihood. Again, it's going to be a marshal, a sheriff, or a constable in all likelihood. You can request a waiver of service. That just isn't done that often, unless you have another attorney on the other side. You've been talking about it. At some point, you're going to file, and they agree that they'll accept service. And you know, again, even still, that's great. But sometimes then, while they say they'll accept it, they're going to sit on it for a little bit. But I don't control the time period anymore. So they don't have to answer until 20 days after they've been served, and they can now decide when they choose to accept service and send it back. So again, even though it's here, it isn't done that often. You don't even always know whether they're represented on the other side at any rate. So normally you serve. What this tells us is that you can also send it by first-class mail if you look at we're looking at the Federal Rules of Civil Procedure, G. But again, what now we're waiting on is the letter to be picked up, and this usually would mean certified as well, by the way. Now what we're waiting on is someone to accept the certified mail and send it back. So again, we've got time periods. So if they ever do, that's correct too. So at the end of the day, the easiest way is, if you want to get the case moving, you give it to a marshal, a sheriff, or a constable. You say, serve the defendant. And it tells you, if you look at, I think it's E. Yeah, E is where it starts telling you how to serve people. And it tells you, and if it could be by giving it to them personally, leaving at the dwelling. Actually, this is 2, right? It's E2, I believe. Yeah, it is. It looks like E2. You can deliver in hand, leave a copy of the individual with someone an adult who resides there, get them to an agent. Most people don't have agents. And then it tells you about serving an individual. The bottom line is, if you look at the list, it's going to tell you how service of process should be made on an individual, on a minor, on a corporation. And as the sheriff oftentimes knows, and the constable knows how to serve it as well. But you usually would provide the instructions as to how you want it served. And for the most part, it's likely to be, you're going to provide them an address, you're going to tell them you're going to tell them that it needs to be served, and that if it's a corporation, usually an agent in charge of the corporation is sufficient. If it's an individual, oftentimes, as a general matter, leaving it at the place of abode, either with an adult and mailing a copy, is likely to be sufficient. There are, as I said before, very few things that have to be served in hand. That if you went through this whole list, it talks about how long, how the process you would use to serve the various entity who hopefully is within your jurisdiction, because just because we're in federal court doesn't mean we can serve anywhere in the United States either. So as you can see, Rule 4 is what's going to allow for you to ultimately provide the service, and it should be done, as it says in M here, within 120 days after the complaint is filed in court. And then once it's served, you're not done, because that service of process has to get back to the court so they can record that the service was actually made, and that when the service date on the summons will actually start the clock ticking with respect to how much time they have to respond, either by way of a motion to dismiss or an answer. And if you think about it, I know we talk about that another day, that at that point, while the clock may start ticking, the fact is, by the time that person makes arrangements with an attorney, you may be asked for an extension of that time so that they can get their act together on the other side. Cost of that, serving that summons and complaint on each defendant could be anywhere from $25, $150, $75, $100. What do you got?
We're serving someone out in Arizona on a case, and the Sheriff's Department in Maricopa County requires $250 prepaid.
$250 on a person of one entity to serve?
Yeah, if there's
Okay.
if there's anything left, they'll refund it. I'm not expecting a refund from the Maricopa County Sheriff's Department.
Yeah, that's kind of high. I think, isn't that the
Because
one,
we're out of
isn't that the
state
place though
and-
where they charge like the prisoners for
Oh,
breakfast
yeah.
and stuff?
Oh,
No,
yeah.
really, right? I think it is, isn't it? They keep them out
They're
in
the
a tent in
ones
the
that wear
desert
all
or
the
something, right?
pink candles.
No, but right, I'm not making that up. It's like, it's like sort of, where you keep.
If they don't grow it or
Right, isn't that?
whatever, they don't eat it.
No, I think that's true, Melanie.
And absolutely.
And you're paying for about
Fantastic.
8 prison uniforms.
Right.
So that's the highest I've ever heard as well.
Yeah, we
serving.
have 5 other states that we're serving in the same manner, and the other ones are mostly like 45 to 75.
But again, between the entry fee and the cost of service, depending on how many defendants, we're already running $300 to $500 here. So that I mean, when you start to think about what do I need for that advance, that becomes important to start to think about, because we haven't touched discovery, we haven't even touched anything that truly will start to run that cash register quickly, but just getting to the first stage requires cash that you really needed to think about when you told them you needed, you know, if you're taking a $1,000 advance in a piece of civil litigation, that's not many hours that you're getting for that, because much of it is the cost. And so you really need to think about cost, getting the advance for cost plus what you're likely to use for a retainer. And that realistically is something you guys have to think about as you start to figure out how to practice law, because we haven't even touched the cost of discovery, photocopying and things like that, and all of that has to go into the mix to try and collect, try and figure out how to get back, because all of those are cost items for your firms and the like. So, well, and as we said, if you get closer to trial, so now you've spent money on your filing fee and your and service, then you spent, depending on the case, some real cash on transcripts and discovery, and that really doesn't even assume you had to purchase an expert, right? But we have the expert in with Lay again. And even in discovery, if you've got to send out subpoenas in discovery for witnesses to come to the deposition, then it's not just the deposition cost, it's serving the summons on the witness and a mileage fee for wherever the witness has to come from to. Now, the mileage fee in Massachusetts is relatively short money still. But again, it all starts to add up, and then if we go to trial, we have to subpoena well, maybe all the witnesses, but at least the unfriendly witnesses, plus provide them a witness fee as well. And even in a relatively simple case, those costs start to add up after a while. And if your client doesn't have the money, you may be advancing those items. So another reason why you better pick the right court when you decide to file the entry fee and to serve the process, because I may not really object to paying $300 or $400 once. So I'm not going to pay it more than once if you made a mistake, because the second time then it comes out of your pocket, assuming we can still file. But all of these items start to get expensive, and realistically, some of that frank conversation about that has to start at the outset, because there's just some basic costs that we're really looking at filing suit. There's some basic costs that are an absolute given, that there's really no getting around. And at the same point, you want to make sure that you're paid some of your hours for, some clients, you will run out of money somewhere in the course of a piece of litigation. And so now you've got a appearance slip in, or your appearance is noted by way of filing the complaint. You may not be getting out, and you're billing, but you're not getting paid, because the money has had to go to costs, and the money you've got a couple hours out of it, but now you're in, and can be a problem. That's why it's important to try to think, and I think it's harder to do it early on. What am I really looking at as a practical matter for how many hours this is like to take to get us to a point where realistically we could be talking some form of resolution about it. And that all has to go into the mix. And the service of process is relatively routine when you start to think and look at the rule. But it's another thing that you've got to start to focus in on how to get it done. And sometimes it can be as expensive as $250, which is outrageous, right? Questions on that? Well, let's talk about Burger King versus Rudgewitz, because again, I like this case. Burger King sues Rudgewitz in Florida. Well, I guess that's my first question. How come Florida? Go ahead.
Because the court had ruled that Rudgewitz had reached out to Florida for the specific purpose of establishing a Burger King franchise in the state of Michigan. So while Rudgewitz did not have any
Isn't that odd language too, that they reached out to Florida to start a Burger King in Michigan?
Mm-hmm.
Really though? I mean, aren't I reaching Michigan? Isn't that where I'm reaching out? Come on, go ahead, Laura.
Well, in the contract, doesn't it say all disputes will be settled
Well, does it? Because then we don't, then we have a much shorter
There's
case.
a choice of law clause.
Is it choice of law or choice of form? And what's the difference? Choice of law? Amber, now you're comfortable it's a choice of law, right?
That's what
Yeah.
it says.
No, I just want to make sure. So it's a choice of law clause, right?
Yes.
What is a choice of law clause? What's a choice of form clause? Because they're everywhere now. What's the difference?
Well, the form would be the venue, and the choice of law would utilize the law.
Yeah, I need like a whole sentence that tells me what it is. If I were trying to write it down like for my notes. So what's a choice of form clause?
Choice of form clause would be related to the venue as it would decide that where would be the hearing would be held, and the choice of law clause would utilize.
Well, just the hearing?
Well, the whole case.
So tell me, give me a sentence. A choice of form clause means what?
The choice of form clause means that the venue would be decided
What's
by.
venue? That's a legal word, right? Can you have a regular, or a word that a layperson could understand? By the way, I think there's talk that the Supreme Court may accept one of these cases with respect to the credit card agreements with respect to choice of venue provisions. Well, what's it mean when you say venue? What's a choice of form clause? Go ahead, I'm still talking to you.
Someone help me.
No, you don't need help. Listen, the choice of venue is correct, but I mean I think that cuts it too quickly. Choice of form clause means what? That if there's any disputes, what?
They'll be settled in
That they have to be filed and heard in that form, right? You were just shortcutting it, and I wanted to make sure we've got the whole thing, right? A choice of form clause means any disputes, for any reason, must be filed in that form, right? That's a choice of form clause. I've got one now. It's a good one. Well-educated person. Service and both the computer hardware and software that was sold to was junk. Pure, well, it's easy. Pure junk. There's a choice of form clause, North Carolina. There's a choice of law clause, North Carolina. So we'd like to use 93A. And there's a choice of form clause is not just a form. It says, and it'll be by AAA arbitration in North Carolina. So it's not a court. It's not Massachusetts, and probably deep trouble. It's just too bad because it's real junk. And 93A, we could do something with, and maybe we can do something under North Carolina law. Who knows? So that's a choice of form clause. What's a choice of law clause? Go ahead.
Choice of law clause is whether the action is filed in either state, the laws of that particular state that's mentioned in the contract or the clause is what governs the outcome of the case.
Right. The choice of law clause says that if there's any disputes, wherever the action may be filed, this is the law that will ultimately control the resolution of that case. And I'll tell you, it makes sense in today's transactions, right? We oftentimes have multiple states that are involved in a given controversy, and to be able to know at the outset, well, there's some certainty if there is a dispute, this is the law. The problem is, I mean, there's ample reason why people would want to avoid the operation of Massachusetts law, one of them being 93A. It provides some real relief to consumers and businesses. And maybe that's also something you ought to think about if you're writing these. Maybe you want to stick Massachusetts law in there for your Massachusetts people. I'm not sure they're going to change the choice of law clause for you, but there's a trade-off there too. I mean, that can be negotiated. Okay, listen, we'll take your choice of law clause, but the choice of form then is going to be mass.
But don't most companies like to use Delaware choice of law?
Again, it depends. That's more on for corporate agreements and for employees, because the law is very favorable as a general matter to the corporation. But a lot of major companies like to use the law of their form state because their lawyers are well schooled in it, there's a certainty to it, and it makes it easier for them to just simply have that in there, assuming, again, the law is good for them. If the law is not good, they'd look elsewhere. But there's a lot of times where those laws do provide some level of comfort to them too, and it doesn't need to be Delaware. Delaware has very strong corporate laws for the respect to the corporate citizen anti-takeover and with respect to the rights of the corporation. But there are other matters where it's not really necessarily a corporate governance issue that's a question, but they simply want these other states' laws to be involved. But at any rate, so this is a choice of law clause, right? Because if it's a choice of forum clause, the case is over pretty quickly. But what we've got is a choice of law clause that says if there's any disputes, regardless of where the case is filed, they need to be resolved using Florida law. So does that mean a court in Michigan could use Florida law to resolve the dispute? Yes. Yeah, right. We've talked about this before. I've talked about it before with some of you. You know, just because a court sits in Massachusetts doesn't mean that we have to use Mass law. They won't in many cases. Could they figure out what Florida law is? Sure. Texas, Hawaii, yeah. You could go downstairs to the library and figure it out. So why couldn't the court? So they're not wedded to the state's law where they sit. It says the state of Florida's long-arm statute extends jurisdiction, blah, 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 blah. What's a long-arm statute? Geneva?
No, go ahead.
Okay, the long-arm statute is
You guys speak up.
the long-arm statute is a way of serving someone outside of the state.
Right? It allows the court to reach someone that is not within the court's territorial jurisdiction, the borders of the state. You know, we tend to think that, well, you can always serve anyone. Well, that's not really the way it is. And that's why we use a long-arm statute to provide that notice. States have different long-arm statutes. And as long as they comport with due process and minimum contacts under international shoe, then they can use that long-arm statute to provide that service to the out-of-state entity. Even the federal court Rule 4 says that you can use and reach those defendants even in federal court by using the state's long-arm statute. And that's what they're trying to do here, because these folks are not citizens or residents of the state of Florida. So the long-arm statute is used to reach out-of-state defendants. We use it oftentimes, see, I don't like the language extends jurisdiction to any person, but that is the way they read. The problem is it's a means of service of process more, but obviously service of process and personal jurisdiction are tied together, because if you can't serve process to someone that meets the standard of, say, minimum contacts and personal jurisdiction, then it's useless to say we've got personal jurisdiction. So they go hand in hand. But there will be gaps sometimes between minimum contacts and the ability to serve the absent defendant. You know, the Massachusetts long-arm statute is one of those statutes that requires more than minimum contacts to file suit here and use our long-arm statute. So you'd see gaps there. Usually in Massachusetts, we require, in order to use our long-arm statute, some additional connection between the controversy and the forum itself. So we don't want necessarily strangers coming in here and trying to use our long-arm statute on a controversy that has nothing to do with Massachusetts. And so usually we look for some greater connection. This case says that the U.S. District Court for the Southern District of Florida, sitting in diversity. What's a diversity case again, quickly? What's a diversity case? Steph?
Where the plaintiffs and the defendants are from different states and the amount exceeds $75,000.
The amount is reasonably likely to exceed $75,000, right? So the plaintiff and the defendant are domiciliaries of different states, and the claim is reasonably likely to exceed $75,000. The fact that you don't exceed the $75,000 is irrelevant at the end of the day if it was reasonably likely that at the outset you would exceed the 75, reasonably likely you would exceed the 75,000. We don't look at it in hindsight, we look at it at the outset. Do you guys think that Rudgewitz and McShara really did do enough in Florida to justify the exercise of jurisdiction? Because, I mean, clearly the majority of the contacts were created and would have extended to Michigan, right? I mean, Florida, do we think, does anyone else think it's a little scant, the contacts? Or no?
Yeah.
Do you think it's somewhat slight? Go ahead.
Yeah, because in Michigan they have advertisements and they even have office there. So I think they should have brought the digital over there instead of in Florida.
Well, wasn't it? It was Burger King who said, "Oh, you know, don't contact the regional office. You guys talk to Florida." Well, you're the one that made me do that contact. I would have preferred much more often to go through the main office. No, I mean, so but that still creates that still is a voluntary contact. When you tell me don't deal with my local office, deal with the main office, that counts against me. Did you see that? Right? That's right. I can see your head nodding your head.
Yes.
That's it. Not contacts, but by both of these guys, because one of them never even went to Florida at all. One guy did, but for a very brief period of time. But there were checks sent back and forth, some equipment, phone calls. That's enough. That coupled with the choice of law. No one feels bad for these two little businessmen who got screwed by Burger King. Go ahead.
I don't think they should have been able to claim jurisdiction over them, mainly because there was no real benefit that they could, or protection, if you would, that they could apply to themselves from the Florida, from the laws of Florida. They didn't do anything that would require them to be able to participate in any benefits or protections of the Florida law, so I don't think they should be able to be liable for any damages that they might have.
In Florida.
In Florida, yeah.
What do you think of that? Go ahead.
I think with doing business with Burger King and them having them be headquartered in Miami, that it's reasonably foreseeable that they would be hailed into court there dealing with them. So
They also negotiated with the Miami office as well, so.
There were some negotiations with the Miami office, but if they wanted so clearly for everything to be out of Florida, why didn't they put a choice of forum clause in there? Why didn't they say, this is where you're going to file? Because now, go ahead.
Well, because for them, it didn't matter whether it was held in Florida or Michigan, because they do business in both, so they could have representatives going to both.
Rudgewitz and McShower, or Burger King.
Burger King.
Well, if it did, though, you don't think it did matter to them? Because why didn't they file in Michigan as opposed to filing in Florida, if it didn't matter to them?
To make it difficult to have enough leverage over the defendant.
So it did matter to them because they wanted leverage. And I agree.
Yeah, so leverage.
Why play an away game if you can play a home game?
Right.
So it did matter to them where they filed.
So then,
No? Go ahead.
Well, I mean, they clearly had a disparity in bargaining power when they entered into the agreement with Burger King, but at the same time, they were both, businessmen that knew what they were getting into. They actually went out and agreed to this.
Right, well, one's a CPA, and I forget what is the other, I don't know what the other is, but, these are not naive people when it comes to business. But is that really fair? I mean, because your first statement was there is a disparity in bargaining power. Isn't there always going to be with the franchisee relationship? I mean, one holds everything, and the other holds next to nothing other than a pile of cash.
Well, that's what you're bargaining for, that you're going to get some of that cash and you're going to give up something else.
And so the disparity in bargaining power doesn't become an issue, really, because it doesn't really matter. Does it?
When it doesn't work in your favor.
Well, but if it's not going to be effective later on, to say, well, what could we have done? And the answer is, because let's be honest, your client brings to you a couple of years from now, they bring you the franchise relationship, the agreement, and I expect you intend to read it all over and advise them of what the ramifications are. Think you can make some changes? I mean, what would you recommend to them? I mean, listen, there's two things you've got to do here, right? You have got to protect yourself against being sued later on for not having told them, oh my God, you should look at this clause 17, you should look at this clause 45. And listen, this whole page about choice of forum, choice of law, waiver of your right to jury trial, waiver of your right to trial, waiver of your rights to this, that. I mean, at the minimum, listen, the deal may go through with or without your advice. But you better make sure then that you've told them the problems with it, and probably told them in writing. And that's always the problem, because I tell them in writing 15 things and I left off the 16th, and the 16th now is the issue. But people are going to forget what you said anyway. And I'm not sure how many changes you're going to be able to constructively get with respect to this agreement. And at the minimum, this choice of law, choice of forum, choice of court or arbitration provision is something that should be clearly explained. Would you ask for a choice of forum provision in this? It's not there. But I know, you've read this case, I know how it works. If they get the chance, they're going to file suit in their home court. And we are going to have some contacts, and it doesn't, I think this case can be read for saying it doesn't need a lot of contacts. I mean, because this is not an extensive amount, although I hear the arguments that there were systematic and continuous contacts between the two states that the defendants, Brunswick and McShara, pursued. I mean, they did, but it just seems like, I think two things bother me significantly about the case. The court says, oh, we've got a choice of law clause here, so they should have expected that they could get the benefits of Florida law if they wanted to, so there's burdens that come with it. And that argument bothers me a little bit. And then the other part that bothers me is the part where they say, well, there was a 20-year contract in place, and so the contacts would have taken place over a period of 20 years. But this is really a divorce taking place in year 2, and we know 18 years of those contacts then will never take place, right? Will never. Go ahead.
Where Burger King is really holding all of the, power in exercising it, is it an oversight on their part that they didn't put a choice of forum clause in there? I mean, they obviously knew enough to put the choice of law clause in.
What do you guys think?
It's a Florida case, they probably would have had to try in Michigan. It's a Florida still.
Oh, you think no matter what, they would go somewhere else? Well, what do you... Well,
and that's a forum non-convenience argument, right?
Well, I'm not so sure it is forum non-convenience, simply because they can argue that's our home state. We ship product out of there. All our accounting is there. The training was there. There's witnesses there as well. My theory on that is that they didn't put a choice of venue provision in here because they didn't want to scare off Brunswick and McShara. If it's there, then I say, no, I'm not going there. Let's make it Michigan. And I think logically that's a reasonable thing to negotiate, because that's where my franchise is. Now I've got a heads up. I want to negotiate that.
I agree with that. I thought it was kind of a business tactic, because I think they still got what they really wanted by the choice of law clause in there, but it wasn't as scary as the choice of forum, because I think that stands out so much more and would have probably put off a lot of other people from trying to open a franchise.
Well, doesn't it raise a greater red flag? Because now I say, oh, okay, now I know. So if there's a problem, I got to go there. And let's be realistic. That's something we would tell our people, is that this makes it a lot more expensive to litigate against them if there's a problem, or to litigate even if you're the plaintiff, having to travel to Florida, file suit, and all the rest of it, and get ourselves an attorney down there. I think it may be more of a tactical decision. If I just put it as a choice of law, I can always use it to support the argument, and you don't get the heads up that when this breaks down, and because we don't want to talk about that anyway, right? I want you $200,000 first, and I want you to sign the franchise agreement. So we don't want to even talk about bad things. Nothing's going to go bad. So when I have a clause like that in there, I think that's more of a business decision that back then, and again, the trend is more towards these, and so to a much larger extent they're generally accepted now.
It doesn't usually deter very many people, because most people want this.
See, Freddie, that's why you're in such a difficult position here as the counsel. And I've had clients say that, I want this deal.
Right.
Don't break it up. No, and they don't use the word break, right? But they want your advice, and they'd like you to really make it clean. But if you could, but if you can't protect me, the likelihood is I still want this deal.
Right. It's similar to the person that wants to go on the cruise that's, you know,
Correct.
agreeing to litigate any problem that they have in whatever, you know, Florida or wherever it says on the ticket, right? I
Yep.
mean,
Yeah.
they
but-
want to go on the cruise, so they're gonna pay for the ticket either way. It's similar nowadays.
I think it's worse, because the cruise is sort of, this is, I want this business arrangement. I've been thinking about this for a while. Go ahead.
I was gonna say, they didn't have as much negotiating power, but there was some negotiations with the cruise. You just go, there's absolutely no bargaining power when you take the cruise and you slip and fall and then have to go to Florida with your broken leg to litigate it, but.
Let me ask you a couple other questions about this case in looking it over. It says, Rudricks and McShire then filed an answer and a counterclaim, seeking damages for alleged violations by Burger King of Michigan's franchise investment law. What's the counterclaim?
A defendant's claim against the plaintiff?
Okay, and what are there more than one kind?
Yeah.
What are they called? What are you saying?
Compulsive and permissive.
Compulsory and permissive, right? There's two different types of counterclaims. Compulsory counterclaim, because it arises from the same set of facts or occurrences as the plaintiff's claim against them. If you do not bring it, res judicata will preclude that from being brought later on. A permissive counterclaim is a claim you have against the plaintiff, but it doesn't arise from the same set of facts or circumstances. And since it does not, you can bring it later on. You don't have to bring it now. You can bring it at some future point, and res judicata won't preclude your bringing it. If, however, you do choose to bring it now, then it has to have a separate basis for jurisdiction because it arises from a different set of facts or circumstances. So Burger King files suit in Michigan, and they file suit in Burger King files suit in Florida, and they file suit in federal court, and they seek a injunction. What do they want to do by way of the injunction in this case? What is the injunction that they're asking the court to give them? What will it do?
Close them down.
Well, what do you mean close them down? They can't sell burgers anymore?
They're still using their Burger King identification and operating.
So they want to take their, well, what? Because I want to know what that injunction says, because you guys have to write the injunction. So what's it say? So you want an injunction enjoining them from, speak up, huh?
From occupying and operating the facility as a Burger King restaurant.
From occupying and operating the facility as a Burger King restaurant. Occupying too? So that means Burger King likely owns the real estate?
Oh yeah, they said they want the keys, but they didn't claim the keys to the building.
So they rented it from Burger King. So so not only can't you operate, because not only can't you stay there, so you can't neither occupy or operate it as a Burger King. Because if they didn't own the real estate, you could sell burgers, you just can't sell them under our colors or our names or anything else. But now this injunction intends to, for all intents and purposes, throw these guys out in the street and remove any of the Burger King intellectual property from being used. And they really do want both here. And the reason they want both is because they also own the location of the real estate, which again, that's not uncommon. We're going to read a Subway case. Subway does the same things with all of their places. Is one entity belonging to Subway owns the real estate, another has a franchise relationship, and Subway is very litigious as well, as we're going to see when we look at those cases, and have problems with respect to their franchise relationships as well. So we want to strip them of all the trademarks, which are the Burger King, the colors, the use in combination like that, the service marks. But the difference between trademark and service mark, service is for a service, like the selling of the burgers, or the trademark is on property and the like, physical things. So they're really, for all intents and purposes, you oftentimes see them together, but one is goods, trades, and the other is more services. And they also want to get prevent them from using the Burger King's proprietary information. So where would they stand a better chance of getting such an injunction? Because this is really gonna shut the business down completely. Certainly shut Rudgewitz and McShara down completely. Where would you like to litigate that? Florida, right?
Where it has no effect on resident employees or.
No resident of Florida is going to lose their job on this deal. No resident of Florida is going to be affected in any way. And, well, the only resident of Florida that's going to be affected in any way is our good corporate citizen, Burger King. And so, again, like virtually everything else, and this is why it becomes important to start to think about how I make that SPV analysis, is that it is much easier to win a lot of these contests on a home court than on an away court. It's also a lot less expensive to litigate it, and it may be nice to fly around the country, but someone's going to pay for that as well. So they want that in Florida, and these guys are arguing, well, we don't want to go to Florida. We don't think we have the contacts, ties, and relations. And I think if you go through this, they give you a few cases that obviously are important that you should remember. Is they talk about International Shoe, they talk about Worldwide Volkswagen, they talk about Keaton versus Hustler Magazine, which is an interesting case. They talk about Helicopteros. The cases that I have are on page 472 and 73, the original decision, and that's as good a description and understanding about personal jurisdiction in that very brief compass as you're likely to get, because all the key phrases are there that you should really take a look at and understand to a large extent. And there's even a footnote, I think it looks like footnote 15 on that page, if I can see the right number, where it tells you the difference between specific jurisdiction and general jurisdiction. And you should know the difference in that, because again, that's one of those areas that does in fact come up, believe it or not, where the court, in trying to determine whether personal jurisdiction exists, there is a difference in the case law, there's a difference in the standard for specific jurisdiction with general jurisdiction, both of which are parts of personal jurisdiction. Specific jurisdiction, as you'll remember, simply means that the contacts in the case are the ones that give rise to the cause of action. And when those contacts actually give rise to the cause of action, the rule is I don't need as many to establish the basis for personal jurisdiction as when the contacts are unrelated to the cause of action. When they're unrelated to the cause of action, what you're telling the court is you're going to establish general jurisdiction, because you have to now. And in order to establish general jurisdiction, you do need more contacts, more systematic and continuous activity with that forum, because only in that way is it reasonable to expect that the defendant was aware that his conduct would bring him within that court's jurisdiction. So you should look carefully at the language in 472 and 473. They give you sort of the greatest hits of personal jurisdiction cases, talks about it's a waivable right. The language there is, I think, very, very good. And it gives you, and I know we didn't read it, I don't know whether you guys read it with Professor Martin, but it also talks about travelers' health insurance versus Virginia, which is a good case. And the language from that says, we have emphasized that parties who reach out beyond one state and create continuing relationships and obligations with citizens of another state are subject to regulation and sanctions in the other state for the consequences of their activities, travelers' health. I mean, that's pretty straightforward and pretty understandable, I think, that should do it. And again, then we go into a defendant who, a non-resident who purposely directs his activities toward forum residents, and the forum has an interest then in resolving those controversies. So that's, I think, really good language as you start to think about it. The next page, by the way, I've got most of that highlighted on 475, 474 for those that want to think a little more about the civil procedure issues involved. This all is language that easily could find its way into your outline from when you did sit pro. but it is something to start to think about and make sure you have a little bit of a better understanding of probably. At any rate, when we get through with all this law, and we add in the choice of law provision within the contract, and we tie in that law to the context, could these guys, and I think this is where we started a little while ago, could these guys reasonably foresee that their activities, that because of their activities, they could reasonably anticipate that they could be hailed into court in the state of Florida for their activities involving Burger King? Yes or no?
Yes.
Now, the court says yes, and it's close, I think, but I can see the logic behind it. I think this is a good case that when you look at it, you think about the best defense is a good offense. I think they should have filed suit against Burger King in Michigan first. And there's no doubt, Burger King has, you can see this one breaking down. When something like this breaks down, it breaks down over a long period of time. And they are not going to let you do this forever. And so if you want to try and argue fraud in the inducement and that they phonied up the numbers and you paid too much for the franchise and now it's not worth what it is, then the likelihood you probably better strike first. First of all, you're in a superior position at that point because maybe you look more wrong when you file it as a plaintiff as opposed to a defendant. B, it wouldn't have taken Einstein to figure out when they sue, they may well be suing down in Florida, and we're at a significant financial disadvantage to have to try and defend this suit in Florida. If you were Rudgewitz and McShara, the place you're likely to get some help, if someone wants to help you, is maybe on the home court as opposed to in a away game. And this sometimes becomes a real issue in litigation, is when things really break down, we have to make a decision whether to strike first. I mean, there's no doubt suits coming at some point in a relationship like this. There's hundreds of thousands of dollars at stake. It's gone bad. If we can't solve it, then we've got to decide how to best leverage our position in litigation so that we at least initially hope to start out with the higher ground. I think this would be one, and I'm not for encouraging, premature litigation, but it's clear, it should have been clear to anyone looking at this that they're going to sue. This is not, no one's walking away from this deal. That, and obviously hindsight's 20/22, but I think they would have been far better off thinking about filing suit in Michigan, where I think they easily could sue Burger King. Then the question obviously becomes, do they have some violations of Michigan's franchise law as they allege? The problem with that might well be we have an agreement that says it's Florida law no matter what, but now, again, if I want to use Michigan law, I got a better shot in a Michigan court arguing successfully with them that Michigan law should protect a franchise relationship within its borders than trying to get a Florida court with a choice of law of Florida telling them that Michigan has the superior law and should be the one used. I want to mention a couple other things about this case that I think are worth looking at. It says in one of the other footnotes that I think it was McShara simply walked away at some point.
He didn't appeal.
Huh?
It says he didn't appeal.
Okay. And so, yeah, McShara did not appeal this judgment. Why do you think that?
Couldn't afford to.
Yeah, that's what I think too. That's what I think. And this is a real consideration, right? At some point, if he doesn't have the dough, winning on appeal isn't likely, or may not even be financially feasible. I don't care. Yeah, maybe I could win, but I don't have the money to keep doing this. And that's as that comes into play when you consider what you have, what options you have available, both from the standpoint of the plaintiff's lawyers as the defendant's lawyers. He just walked away. You can tell me I owe $50,000 or $5 million. Doesn't make a difference. I don't have any of that money. I have nothing further to lose. I'm out. And so even during appeal, there were some things going on here that would make you think a little bit about, what is it we can do. The problem is, no matter what, Burger King can't simply walk away from this. We can't allow a franchise to simply not pay what they're supposed to be paying and do what they're supposed to be doing, but continue to operate as a franchisee. I mean, the whole notion of franchises is they virtually have to be identical in order to have value to the whole. And so they've got to force some form of resolution to this, even if it means stripping them of the franchise relationship. Stevens and White, I think, have an interesting dissent, and it starts out with there's a significant element of unfairness in requiring a franchisee to defend a case of this kind in a forum chosen by the franchisor. Well, what do we got? We got 2 votes here, maybe 3, if Powell was in, but Powell's not. Yeah, of course there's some unfairness. But if we think about this case and the language in this case, how is this different than any other franchise relationship where you're going to be reaching out to the parent company, there's going to be checks sent on a regular basis, there's going to be reports, I'm sure, required to be sent on a regular basis, there's going to be personnel that you're asked to speak to and talk to about the operation of the franchise on a regular basis. I mean, in reading this case, it's really not difficult for any other franchisor to sit there and say, well, we could set up required contacts in place that will assure that we'd never have to go to one of these little towns to have to defend what we did. And if you were representing the franchisor, that's precisely what you should do. And my guess is the next time we're going to see, and you're going to see them, is choice of forum provisions in as well, and then we even have less to worry about. The problem is, I think that that's a business decision they're making, but they know, reading this case, we don't need that. We know the likelihood is we're not going to have to go there no matter what anyway. So there's not just a level of unfairness, there's a significant level of unfairness, I think, but, and this is something we can talk about a little next time as we think about the Zapata case, isn't there a significant level of unfairness, period, in the franchisor-franchisee relationship? You're going to do what I say, and if you don't, you're not going to get to sign the agreement to begin with, because we can negotiate all we want, but there's not going to be any substantive changes in that agreement for the most part, because, again, I need the consistency in application, and B, at the end of the day, I have more money and power than you will, and you will lose. So, I mean, the judge is right, but unfairness is pervasive throughout that relationship. So, think about it, and think about, because I really like to know what your advice would be, other than don't sign. That's not, and that may be your advice, but let's be realistic. Okay, don't sign it, but I'm going to sign it. I'm going to sign it. Now, what can you do to help me? All right, let's be realistic, because that's really the way. Don't sign this, okay? But I'm going to. So tell me how you help me. And it may not be possible. So we'll talk next time. We have Subway is tough. There's cases everywhere. So everywhere.